Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Nitin Bhatnagar with us. Advocate Bhatnagar has more than a decade of experience in IP enforcement and IP litigation. Having worked for a big IP litigation firm for some time, he started his own law firm called NKB Legal, which is located in New Delhi, India, and with representative offices in Bangalore, Lucknow, and Chandigarh. Today, he has vast experience of handling cases not only in various parts of India, but in other foreign jurisdictions as well, including the United States, United Kingdom, UAE, and Nepal. He has worked for a prominent law firm in Los Angeles, California, and handled their litigation back here in India. So let me introduce you to the man himself. So hello, Mr. Bhatnagar. Thank you so much for joining us.
Hello, Nikhil. How are you?
I'm doing great, sir. It's really a pleasure to have you here.
Pleasure for me as well. You people have been doing very excellent work.
Thank you so much, sir. Now, Mr. Bhatnagar, can you please guide us through your journey?
Journey. The journey has been full of challenges and obstacles, and which were soon conquered by virtue of hard work and dedication. That is all I can say. It's been a good journey, quite a memorable one. Maybe I'll write a book someday.
Sure, sir, sure. And we'll be, we are actually waiting for that moment only, because you'll be actually guiding us through your journey as a legal experience. And yeah, so we all are actually waiting for that moment.
That's so nice.
So,
yes.
Yeah, Mr. Bhatnagar, now moving forward, I would just like to ask you about any complex legal issue that you worked on, and also describe the complexity and tell us how you approached it.
See, in the recent times, one of the most complex and challenging issues which comes to my mind relates to large-scale IP infringements. Filing a common lawsuit to counter large-scale IP infringements for fast-moving goods, the FMCG goods. So it is around 2018, 2019, we were working for this client of ours, which is India's most prominent packaged drinking water company. We have we had been getting reports of infringements from all parts of the country. People were trying to get as close as possible to their labels, to their names. Somebody is just swapping two alphabets, interchanging them. For example, somebody, like if it's Bisleri, somebody comes and says Bisleri instead of BIS, they say BES. So it becomes almost a near identical infringement. So the problem before us was the expense and the quantum of infringements, because these infringements were being reported from every nook and corner of the country. And it was practically not possible for the FMCG major, no matter how big the company is, it is not possible for a corporate entity to have cases all across the country. If somebody is infringing my brand in Tamil Nadu, I go and file a case in Tamil Nadu, and then I file similar cases in every state, in Karnataka, Andhra Pradesh, and almost all over the country. So the challenging task before us was to control them through a single lawsuit, or maybe a couple of lawsuits. For this, we refer to the ancient English concept of John Doe orders, though that is no longer ancient. And in fact, in the Indian system also, it has become very prevalent and very popular now. But the hardest task before us was to convince the court with a case, with a substantive cause of action, which would necessitate the issuance of such blanket orders. Because with the John Doe orders comes larger responsibility as well. And so you need to build a very strong case, and you need to show the court that you deserve to secure such an order with which you can, carry out enforcement actions on almost all infringers and bring them under the umbrella of a single lawsuit. So for that purpose, we took out several citations from the English law, and then we took out previous citations from our Delhi High Court and some previous similar cases. And we were able to build a very strong case, and we were able to demonstrate to the court the deep-rooted penetration of infringements in our system. And the nature of the product, which is, a bottle of water, it's just 10 rupees or so, or maybe 20 rupees or so. So considering the FMCG nature of the goods and considering the level of infringements, considering the way our case was prepared, I think we successfully got it executed, and we obtained this John Doe order where only 6 defendants were initially included. 6 of them being known defendants, and today we have around 70 defendants in that case, and it was an arduous task for us to first get such order and then to implement it with equal efficacy and competence. So that was one of the most challenging tasks for us, and we approached it on the basis of very deep-rooted research of not only the Indian citations and Indian legal system, but also the English legal system from where this concept has originally flown. Because John Doe, the word itself, literally means he who is not known. So we are running after an infringer or a defendant who is not known to us. So we lately identify such party and then execute the enforcements on it. So that's by far, I remember, the most challenging aspect of litigation practice so far, and this is how we approached.
Thank you so much, sir, for telling us about that particular case. And now that we are still struggling to get out of the pandemic, so the pandemic saw some courts begin moving towards more remote proceedings and availability. So is this sustainable and a possible way to increase access to justice, in your opinion?
In my opinion, yes. In fact, in my opinion is very steady and strong in this segment. In fact, I feel this is the future. This is the future. No longer running around from one court to the other. If I have a case listed before the lordships in the Bombay High Court, I can argue it from here. And likewise, my counterparts in Bombay can argue a case in the Hon'ble Delhi High Court, and so on. See, so much of wastage, we have seen at times. I have seen counsels traveling from Arunachal Pradesh, from Guwahati, from Chennai, from Bangalore, all the way to Supreme Court in New Delhi. And they come all over at client's expense. And a number of times this is seen that the matter itself doesn't reach. The counsel comes in the morning and goes back empty-handed without even arguing the matter. So all these things can be taken care of, and remote proceedings, see, there is, of course, there are certain improvisations which will be required to be done, technical improvisations in terms of having proper bandwidth, having equal accessibility of remote gadgets to all our advocate friends. See, we cannot belittle or undermine any advocate's practice. That is, we have to be circumspect of the prospects of equality in the profession. So if somebody is not having those kind of facilities in the office, then they need to be provided, they need to be generated. Maybe in the courts, we can have larger IT cells which can facilitate the counsels in participating in such remote proceedings. But yes, definitely the way, in fact, I would say the pandemic has given a blessing in disguise to the legal fraternity. Until 3 years ago, we had not even thought. There was, it was a distant possibility to even think of courts, even the highest courts as well as the lowest courts, functioning remotely. through internet, through WebEx, Cisco WebEx, and platforms like this. But then this became a reality, and at times when there is no distortion, no IT hindrance, no interference, the pleadings are as good as they are conducted in the physical court. So it saves a lot of man hours. It saves a lot. You can channelize that energy in other better constructive things. Though there is a segment of people which is not understanding this and not appreciating this at this stage, but then in my strong opinion, this is the future. And in fact, in American litigation, this has been into practice for something like 2 decades now. I have a lot of American friends appearing before the US courts. They generally appear before through video conferencing. So this, in my opinion, is the future of Indian litigation.
All right. Thank you so much, sir, for telling us like how beneficial the virtual platform is. And now moving further, in your opinion, how do you make future lawyers ready for a technology-based litigation practice?
How do we make future lawyers? Okay, all right.
Exactly.
We have to make improvisations in the law school. See this, our Honorable Supreme Court of India has already been stressing, and even the bar councils have already been stressing time and again, a number of times, that the level of legal education needs strong reformation in India. See, barring the NLUs, the National Law Universities, we have very few institutes which are maintaining good standards of legal education. So when we take up that improvisation, definitely the law schools will also have to take the initiative to bring in such futuristic techniques, and maybe they can include some parts of IT in the curriculum, just the way they have subjects like the legal drafting and English language. They can even start some IT sessions where the students studying law would be taught about the aspects of internet technology, the WebEx meetings, Cisco meetings, and how to use the internet. Because you see, it has to be done at the level of educational institution. Because today the concept is that even when you are filing a matter, even at the stage of filing, the registry asks you to properly bookmark your file. If you are filing a petition of 100 pages, they will ask you to make a table of contents and bookmark it. Where is the memo of parties? Where is the notice of motion? Where is the petition? Where is the relief clause? Where are the annexures? So if students will not learn this during the law study itself, it will be a Herculean task for them to adopt these technologies once they come into active litigation practice. So in my opinion, the law schools will, and I'm sure they will start holding some training sessions, maybe some webinars, seminars, and on the lines of the moot courts itself, they can also have virtual moot courts. A lot of institutes are already having the virtual moot courts. So definitely, if the question is how do we make future lawyers ready for a technology-based litigation service, the answer is it has to be initiated and it has to be done at the law school level. Though once they come into practice, the courts can also organize some short-term, maybe a 3-day IT session for young professionals, advocates enrolled within the last 2-3 years can, just come and participate in such events, which some courts are also doing. But then this will have to be imparted as an education itself. In fact, I would like to mention in research also. You see, what research used to be about 15 years ago, it is no longer the concept now. You don't need to go and sit whole day in the court library, running across law journals and trying to pick up some judgments. Today, you have the Manupatra membership, India Kanun, and several other platforms. You just type the cause title and you get the desired judgments. You type the area in which you are trying to conduct some search and you get good results. So for a good litigation practice, the education has to be improvised. Law schools will have to play a very good role in bringing this into the system.
Okay, what I understand from here is, sir, that it's the initial part of a of a student's life where they get to learn the things which they won't be able to learn at the later part of the stay, right?
Yes, I mean it is. It's not that they will not be able to learn. It will take time. Suppose I have, in my office, like some young student, a law graduate, a fresh law graduate joins as an associate. If he is coming from a very remote location where he did not have access to all these IT gadgets and tools, and he's not even aware about how the legal research is conducted, I don't think he's of much use to. Because what I need in my office is a person who knows that yes, Manupatra works like this. I have to do the filing like this. The e-filing portal works like this. So basically, the idea is that he can be given an on-the-job training, maybe for a day or a 2 or 3, to get into the system. But the basic knowledge is something which he needs to bring from the respective institution from where he's coming. And a lot of institutions are doing it. We are having virtual moot courts, and we are having contributions to the, especially after the pandemic, where institutions have started this, and I'm sure this is going to grow stronger, and there will be a stage where this will be included. This will need to be included in the curriculum, maybe as a not as a mainstream subject, but something as an assistive subject, which is required. Because if you see English language, anybody who comes and starts practicing law, takes admission into a law school, if it's a 3-year course, he's already a graduate. If it's a 5-year course, he's a class 12 passed student. So in any case, there is no essential condition for him to study English, but still English is taught, at least in the first semester, in the first year, English is taught. The idea is to polish his skills. So likewise, even this will be done. I'm very sure the law schools and educational institutions will play a very constructive role in this. And this is the call of the time. So they will have to do it.
I understand, sir. Thank you so much for that. And now I would like to ask you, like, what are the main areas of your practice, and tell us something about your clients and the kind of work you do for them, and how do they get benefited from the same?
Our client portfolio is very diverse. We have intellectual property as one of our key fortes, the key areas. Some of our clients are some of the biggest companies in India. Bisleri, as I said, is one of them, which is one of the most prominent drinking water brands in India. Then we have Gulf Oil, and we have Nureka, which is Dr. Trust. And likewise, we used to have Ruchi Soya earlier. And so good corporate companies are there for whom we are doing the intellectual property work. But apart from that, we have a lot of land acquisition matters, revenue matters, and we are also on panel of some banks. We are handling SARFAESI and cases and recovery cases for them, property verification, title verifications and all. Though that's not a very, very big portfolio, but we are doing it. We are on the panel of LIC Housing, GIC, I'm sorry, LIC I said, GIC Housing Finance Limited. And we do a lot of service matters. In fact, I personally do a lot of service matters because I've been associated with the government litigation for quite some time. And recently I was appointed as a senior counsel to the Ministry of Education, Government of India. And I'm looking after cases for the Kendriya Vidyalaya Sangathan, which is an autonomous organization of the Government of India. And they have many cases of all kinds. So basically, you can say that we try to do everything under the sun, but we have diverse portfolios. We have different people in our firm handling different kinds of cases. Like we have with me, the criminal portfolio of the firm is handled by another associate of mine. He's Advocate N.K.Bhatnagar, Gupta, and then the IP portfolio is looked after primarily by one of my colleagues, Ankita, Seth. And likewise, we have different people handling different departments of litigation. But holistically, yes, I argue a lot of them, and I argue in IP, I have argued matters in the banking segment and the service matters, of course, since I am the one empaneled with the government, so I have to argue those matters. So we have a diverse portfolio. By God's grace, I must say.
Now, first of all, congratulations, sir, on starting a new position with the Government of India.
Oh, thank you so much.
Now, sir, as you are also standing counsel for the ministry in the Government of India, and how do you differentiate between that part of litigation and corporate litigation?
See, ultimately, the work to be done is more or less the same, but the methodology of doing that work is different. When we work for the corporate sector, we have a legal department in the client organization, and normally it is just 2 people or maybe 3 or maybe 4 people with whom we have to deal. And so there is a fixed pattern, and based on our wisdom and intelligence, the drafts also take less time to get approved in the corporate sector because we do our work very responsibly. So the methodology is, I would say, the methodology is simpler. When we work in the corporate sector, the methodology is simpler. But when it comes to the government litigation, see, the methodology is definitely more complex and more time consuming, because at times in the government sector, it is not about one case or one particular case or one peculiar petitioner or respondent. The question in government cases is generally larger than what it appears. Basically, the ramifications of that one case could be having crippling effects all across the Union of India. It could have cascading effects on the Union Exchequer, cascading effects on public money. So at times in the government sector, when we are engaged in a matter, we have to hold meetings up to the highest level. There are certain files on certain sensitive matters which even go up to the additional secretary or the secretary of the concerned ministry, and in some cases the files may even go up to the minister. And we have to seek pair-wise opinions and the way they are to be defended. We have to rely on lots and lots of previous office memorandums issued by the government, the Department of Personnel and Training. So, because Government of India is a robust setup, you can very well imagine millions and millions of people. In the Indian Railway itself, there are more than 1 million people. So, the effects of government litigation are much wider in the society. So, I would say that it is more time consuming, and but it is equally satisfying also. When you speak for the government, you speak with certain authority. So that is some area, that is some amount of satisfaction or maybe self-satisfaction, I would say, which you don't get when you are appearing for a private client or maybe a big company. Of course, that is also a pride in itself when you are representing a big corporate house in India. But of course, when you are representing the Union of India, at times there are cases and there are orders where you're holding brief not only for one organization, but for the Union of India, for the Ministry of Finance also, because the issue involved, because the issue under dispute involved the Ministry of Finance also. So they adopt to your own response or your own reply. So in a way, you appear for the complete Government of India. So that itself brings a sense of pride and authority in you. So I would say, I've at times heard people saying that in the government sector, no work is done, or maybe work is not done with due care and caution. But that is one area where I would like to, strongly differ, because I have seen how robust is the working of the government. There is each and everything is meticulously planned. We have a set of policies defining everything, and it's a very satisfying, very wonderful experience to work for the Union of India, for the Government of India. And that's perhaps the best achievement which we have had, which I have had in my litigation career so far.
Thank you so much, sir, for sharing all that information. And now, if it is really rare to see combination of someone practicing corporate sector as well as for the government. And how do you find this unique combination? Which part you enjoy here more? And tell us something about your comparative experience.
The comparative experience I told, see, these are two distinct areas beyond the scope of comparison. If I am representing a big corporate entity, for example, if I am standing before the court and maybe representing a company which runs into 1700, 1800 crores, there is some amount of pride which I hold in me. At least I have done something to be competent enough to represent this company. I must have had some merit in me. But these, you see, they are and they pay you well. You hold a satisfying career because of that part of your litigation practice. So definitely, that's a very good and very satisfying achievement. And then when you enforce other key aspects like those of amalgamation, mergers, acquisitions, legal studies, opinions, but that's an altogether different experience. The corporate sector itself is an altogether different experience. But when it comes to the government, you may not be financially rewarded to that extent, but you are dealing with some of the very, very highly intense subjects. So that gives you a sense that somewhere down the line you are making some contribution to the societal mainstream. You're making some contribution to the country, which has given you everything. So there are people in the government who file frivolous cases against the governments seeking benefits to which they are not lawfully entitled. So to put across the word of the government and justifying the non-grant of such benefits to such non-deserving people is itself very, very satisfying. So I would say it would not be fair to carry out a comparison. But then, yes, it polishes you when you work for the Government of India. It altogether puts you on a different pedestal and a different platform. So if you honestly say which part do I find better, then I would say definitely maybe perhaps I'm getting a step closer to a position where I can make more meaningful contributions to the legal system of this country. So I would rate the experience of working as a government counsel on the first pedestal, and then of course with no offenses made to all my distinguished clients, the corporate litigation practice on the second pedestal. But that's more financially rewarding for me. So that's my bread and butter. So I
Exactly, sir. So exactly, as someone rightly quoted, sir. So it's not always about the money. So there are some things.
Yes.
Exactly. So there are some things which actually gives you peace and something that you actually are in need of.
Yes. Especially in our profession, where so much of greed, so much of corruption, and so much of unfair things are prevailing in the societal mainstream today. I think people with good, crisp and honest vision need to come forward and protect the interest of the societal mainstream as well as the interests of the government. But the interest of the government is the interest of the nation. And I'm sure the Government of India is one of the most robust machineries today across the world. Like I have traveled almost the entire Europe and USA, Australia. I've traveled across and I have seen, personally felt the stature of the Government of India. People recognize us, look up to us with a very respectable perception. And we are a country which is becoming more powerful day by day. So I think it is good for us to make at least some meaningful contributions to the best of our ability, whatever best we can do. So far, I would say a combination of both these segments is very satisfying to me.
Exactly. Now, so thank you so much for sharing such great insights with us. And we look forward to having a chat with you again in the future on some other trending topics in the international legal world. So for our viewers, if you like this chat with Mr. Nitin Kumar Bhatnagar, then please like and share this video. And also subscribe to ClickAway YouTube channel to appreciate what we do. And you have more coming from the legal space. So this is Nikhil for Let's Talk More.